Share, IA next. Page. Here's a detailed study note based on your outline. _ Chapter 1, The Notion of Contract. 1.1 The Notion of Contract. 1.1 Contract as an agreement intended to create enforceable obligations. A contract is a legally binding agreement between two or more parties that creates enforceable obligations. Essential elements include offer, acceptance, intention to create legal relations, and consideration, or causa in civil law traditions. 1.1 Two legally binding agreements that are not contracts. Some agreements are legally binding but do not qualify as contracts. Family agreements, for example, marriage settlements, trusts and wills, legal instruments rather than contracts. Public law obligations, for example, tax obligations, licenses. 1.1.3 Legally binding agreements that are more than just contracts. Some agreements contain contractual elements but also involve public policy considerations or statutory obligations. Employment contracts, regulated by labor law. Consumer contracts, governed by the Consumer Protection Act 68 of 2008. Administrative contracts, between individuals and government entities. 1.1.4 Definition of contract. A contract is defined as an agreement entered into voluntarily, between parties with contractual capacity, with the intention of creating legal obligations, and supported by valid causa or consideration, depending on legal system. _ 1.2 Requirements for a valid contract. A valid contract must meet the following requirements. 1. Consensus, agreement, mutual intention to be legally bound. 2. Capacity, parties must have the legal ability to contract. 3. Legality, the contract's purpose must be lawful. 4. Formalities, certain contracts require specific formalities, for example, written contracts for land sales. 5. Possibility, the contract's obligations must be objectively possible to perform. _ 1.3 The nature of contract. Contracts regulate voluntary obligations arising from agreements. The principle of pacta sunt servanda, agreements must be honored, underpins contractual enforcement. _ 1.4 Contract and the law of obligations. 1.4.1 The concept of obligation. An obligation is a legal bond requiring a party to perform a duty. Contract law is part of the broader law of obligations, alongside delict, tort, and unjustified enrichment. 1.4 Contract and delict. Contract, based on agreement between parties. Delict, tort, based on wrongful conduct causing harm, independent of agreement, for example, negligence claims. 1.4.3 Contract and enrichment. Unjustified enrichment occurs when one party benefits at another's expense without legal justification. Contracts can intersect with enrichment law, for example, when a contract is void, but performance has been made.